Hello. So we have been discussing administrative law, and up until now, in our previous lectures, we have examined the types of delegated legislation in India, which we started in our last lecture. Rules, regulations, bylaws, schemes, and notifications. However, delegated legislation, it it raises a very fundamental constitutional concern, because now you are under delegated legislation, you are giving power to the executive, to the civil services, to perform, to take decisions. So a very fundamental uh, constitutional concern is being raised. Bureaucracy is now formulating laws. It is now creating laws, although under the broader ambit of the constitutional law and the statutory law, which has empowered it to do so. If administrative authorities are allowed to make laws, how do we ensure that these powers are not being abused by them? You'll have to remember that delegated legislation, it involves lawmaking by the unelected representatives, unelected authorities, unelected, while as the primary function of lawmaking was entrusted under the democratic state to the legislature. But under the garb of delegated legislation, it is the executive authority which is making laws now. Laws were to be framed by the legislature, but laws are being framed by the bureaucracy. In that aspect, we'll have to go deeper into understanding the control, if at all there is, and how that control is ensured. So that's why in today's lecture, we're going to understand the control of delegated legislation. Okay. So administrative law actually provides three different kinds of mechanisms to control this phenomena of delegated legislation. So it gives us three. Delegated administrative law gives us three forms, three ways, three mechanisms to control delegated legislation. The parliamentary, the judicial, and the procedural. So we have the parliamentary means of controlling this uh, excessive exercise of power exercised by the bureaucracy under parliamentary mechanisms. We have judicial mechanisms and we have procedural mechanisms to establish that. These mechanisms ensure that delegated legislation it operates within the framework of rule of law and within the ambit of democratic accountability. And how it actually ensures to do that, we'll try to understand that now. First, let's try to understand the first one, which is the parliamentary. So now we're trying to understand the parliamentary control of delegated legislation. How does the parliament control delegated legislation? Since delegated legislation itself derives its authority from the legislature, which is the parliament. So parliament must supervise how this authority is exercised. It's important for them to, because they are the ones delegating it, so they have to supervise what is happening. This parliamentary exercise of power, of control over delegated legislation is expressed in several ways. Parliament does it in certain ways. Like control at the very onset, which is control at the delegation stage. Control at the stage of delegation. This is the first level of parliamentary control, which occurs at the time when parliament passes the statute, the parent statute, under which power is delegated. At this very stage only, it is the parliament which determines scope kya rahega, which we have understood in our last lectures. The scope, the objective of law kya rahega. Remember the previous lectures when we talked about what all are the objectives it aims to achieve. So objectives of the law, limits within which administrative authorities may act. So it's defined at the very onset. In other words, we can say that Parliament decides how much power will be delegated and under what conditions it will be delegated. इसीलिए legislative framework itself acts as a very important safeguard. Another important way that it is controlled is something called as the laying procedure. Laying procedure. Laying procedure. Under this procedure, rules and regulations they are made by the administrative authorities. They must be placed before the parliament. That's why lay, to lay something. So laying is this procedure where the laws now, which are made under delegated legislation by the bureaucracy, by the civil services. So these laws are taken and they are placed before the parliament. This allows the members of the parliament to examine this delegated legislation. So there are various types of laying. Laying is not a simple procedure. Although there is one type of laying which is called the simple laying. Simple laying. And simple laying, the rule is simply the rule which has been made by the bureaucracy that is simply placed in front of the parliament for information. Parliament may discuss it, but does not necessarily vote on it. Okay, this is called simple laying. Then there's another type of laying. It's called negative laying. Under this procedure of negative laying, rules become effective immediately, but they can be annulled if Parliament passes a resolution against it within a specified period. That's the negative laying. So laws, rules which have been made by the uh, bureaucracy, they can come into effect immediately, but negative laying also means that the Parliament has the can annul it if the Parliament passes a resolution. Okay? Then there's another type of laying which is called as affirmative laying. Affirmative, as opposed to negative laying. Under this system, rules become effective only after the Parliament explicitly approves it. So the Parliament has to approve it. That's why the affirmative action of the Parliament is needed, is required. So once that is done, then they come into operation. So this is the strongest form of parliamentary control. This is the strongest form of parliamentary control we have. Next, Parliament also ensures control over delegated legislation through parliamentary committees. Parliamentary committees. So in Indian context, most of the important committees on such topic is the Committee on Subordinate Legislation. So we have a committee. It's called the Committee on Subordinate Legislation. I told you delegated legislation. We discussed it in our last lecture, how delegated legislation is also called as subordinate legislation. So we have a Committee on Subordinate Legislation, and that does this work. This committee examines whether delegated legislation, which has been made, does it exceed the authority that is given to it by the parent law? It imposes unnecessary, does the law impose, delegated law impose unnecessary burden on the citizens, and if it violates constitutional principles. So these are the things that this committee undergoes. These committees play a very important role in ensuring that administrative rulemaking is very, very accountable to the Parliament. Okay. Now, there's another control. So this was the parliamentary control of delegated legislation. This was the parliamentary control of delegated legislation. Now let's shift on to the judicial control of delegated legislation. Judicial control of delegated legislation. This is the second major mechanism of control after the parliamentary system, which we are trying to understand. So this control is by judicial review, which we have talked about. Courts have the power to examine whether delegated legislation is legally valid or not, the power of judicial review, which we have discussed. So under that power of judicial review, it is important that the courts examine, and if administrative authorities have exceeded their power, courts may declare this delegated legislation as ultra vires, as invalid. So judicial review, it operates primarily through the doctrine of ultra vires. Okay. Now, judicial control over the delegated legislation is ensured through judicial review. The courts satisfy themselves that of the substantive ultra wires, ठीक है, सब्सटेंटिव अल्ट्रा वायर्स उस टाइम पे ऑकर होता है जिस टाइम पे जो डेलीगेटेड लेजिस्लेशन है इट हैज गॉन बियॉन्ड powers granted by it from the parent substitute, parent statute. So जितना आपको पावर दिया था पेरेंट लॉ के अंडर, पेरेंट स्टैट्यूट के अंदर, आपने अगर उस पावर को एक्सीड किया है, आप उससे ज्यादा, आपको बस बोला था यहां तक जाना, आप अगर उससे बहुत आगे निकल गए हैं तो उस टाइम पे सब्सटैंटिव अल्ट्रा वायर्स कोर्ट्स जो हैं सेटिस्फाई हो जाते हैं दैट they have exceeded their power. Now, this substantive ultra wires is more or less similar on account of there's this when you must have studied writs in case of Supreme Court and High Courts. Writs. So there's this writ called prohibition. Then there's this writ called certiorari, which means, again, if you've studied it properly, it means the same thing. Preventing someone who has exercised much more power than is allowed. So, for example, if a rule imposes restrictions on something or someone which are not authorized in the enabling law, then the courts may strike it down. And that would be under substantive ultra wires. Then there's the procedural ultra wires. There's the procedural. Now, as the name itself says, it is through the procedure. So it occurs when administrative authorities, they fail to follow the procedures which have been, were meant to be followed and which were discussed and laid out in the parent statute. So once that is, if that is the case, these statutory procedures are violated, the rule itself, according to the courts, becomes invalid. So that is the procedural ultra wires. Okay. They can also embark upon violation of fundamental rights. Violation of fundamental rights. If the courts are, if they are of the opinion that this law which has been formed is jeopardizing the rights of the people, then courts may also invalidate this delegated legislation if they violate constitutional provisions of fundamental rights, because they are the guardians of fundamental rights. So if that is being violated, then it will be struck down. Okay. This aspect mein Supreme Court has repeatedly, the Supreme Court of India has repeatedly emphasized that essential legislative functions cannot be delegated. One of the most important cases in this context is the Delhi Laws Act case of 1951. In this case, Supreme Court had held that while the legislature may delegate certain powers, it cannot delegate its essential legislative function of determining policy. Get it? So that's why it becomes very important. Thus, the legislature must also always ensure that and establish basic legislative framework. This is the judicial control of delegated legislation. Now let's try to understand this procedural control. Procedural control of delegated legislation. Certain statutes, they require administrative authorities to follow specific procedures while framing laws. So there are certain specific procedures that needs to be followed. A, then D, then B, then C. So there's a procedure which is to be followed. First come here, then go there, then this has to be done, then this will be done only after this. So there are certain procedures that are required of administrative authorities. These procedures they may include prior consultation with a stakeholder, right? First C, then A, then B, whatever be the case. So these mechanisms ensure transparency and participation in administrative lawmaking. Okay. Procedural control. It also includes the requirement that delegated legislation be published in the official gazette, official gazettes. There's an official gazette of India, there's an official gazette of the states. So procedural control, it also talks about that publication in the gazettes. Publications, what do? They ensure that the citizens, they are informed about the rules that are governing them. That's what it does. Without proper publication, delegated legislation may not be enforceable, because people need to know what is prevented, what is prohibited, what is being done, which is lawful and with what is not lawful. So these procedural safeguards ensure both transparency and fairness in the, so they bring in transparency and fairness. In the administrative governance. In the Indian context in particular, delegated legislation has expanded significantly. We talked about it in detail due to the growth of the regulatory governance in India. Government departments, regulatory agencies, they frequently issue rules and notifications and bylaws. We've talked about them. So, but India, however, in Indian context, parliamentary committees and the constitutional courts, they, not the tribunals I'm talking about the constitutional courts, they play a very important role in ensuring all these powers are exercised within uh, the ambit of responsibility. They're exercised very, very responsibly. Judicial review under Article 32 and Article 226, for 32 and 226, which talks about judicial review. You must have understood it in polity by now. So these articles of the Constitution, they enable citizens to challenge administrative rules that exceed the administrative authority. Just we discussed them in certiorari and prohibition and writs like that. Thus, Indian system we know provides this procedural safeguard towards this delegated legislation. Okay. So that concludes our delegated legislation. Now, there's another very important phenomena that has arisen. So let's try to understand administrative adjudication now. Up until now, we have studied control of delegated legislation, where we saw how administration, its rule making is kept under control through parliamentary control, judicial review, procedural safeguards. Now we move to another extremely important topic, that is administrative adjudication. Remember, modern governments don't only make rules and procedures and policies. They don't only do that. They are frequently involved in dispute resolutions. They're involved in administrative, which involve administrative decisions. So they are frequently involved in resolution of these disputes, which involve administrative decisions. These disputes, which they are involved in, they arise out of taxation, let's say, labor relations, industrial regulation, environmental compliances. And in every such dispute, if it was to be brought before the ordinary courts, the judicial system would become overwhelmed, which is already under a lot of burden. That's why modern governments resort to something called as administrative adjudication. So these systems have developed with specialized mechanisms for dispute resolution, but in the ambit of legislature, executive. And this mechanism is known as administrative adjudication. Now we are embarking upon understanding administrative adjudication. So this administrative adjudication, it refers to the process. It's a process by which administration, it resolves disputes and determines right through the quasi-judicial procedures. In simple terms, it is a process where administrative agencies perform the judiciary-like functions. जो functions judiciary उठा रहा है, वो functions अब administration उठा रही है. ये agencies cases सुनती हैं, they examine evidence, they interpret law, and they issue decisions which are binding. Unlike the ordinary courts, these ones function within the administrative structure of the government. Unlike the normal judicial courts, which are totally outside the ambit of the legislature or the executive. Administrative adjudication as such represents a fusion of administrative and judicial functions. Administrative functions and judicial functions ka fusion it emerges to be. जो भी administrative law के scholars हैं, they often define administrative adjudication को as process जिससे administrative agencies determine करती हैं disputes को, उनको उन पे verdict देती हैं, जो involve होते हैं around administrative rules, rights, obligations, quasi-judicial procedures के through. ये decisions affect करते हैं citizens को. ये डिसीजंस इफेक्ट करते हैं सर्विस मेंबर्स को, कॉरपोरेशंस को, गवर्नमेंट एम्प्लॉयज को, रेगुलेटरी एंटाइटल वालों को. सो ये एडमिनिस्ट्रेटिव एडजुडिकेशन बहुत इंपॉर्टेंट रोल प्ले करता है मॉडर्न गवर्नेंस में. इसका ही एक एक्सप्रेशन इंडिया में हमें नजर आता है थ्रू ट्रिब्यूनल्स. अगर इसका हम हिस्टोरिकल एविडेंस, इसका हिस्टोरिकल इमर्जेंस देखें, एडमिनिस्ट्रेटिव एडजुडिकेशन इमर्ज हुआ प्राइमरली इन रिस्पॉन्स ऑफ ग्रोथ ऑफ द रेगुलेटरी स्टेट. जो हमने रेगुलेटरी स्टेट की तरफ जब हम चले गए, 19th सेंचुरी में कोर्ट्स जो थे वो हैंडल करते थे मोस्ट ऑफ द डिस्प्यूट्स जो इन्वॉल्व होती थी गवर्नमेंट एक्शंस में. गवर्नमेंट एक्शंस के साथ जो कोर्ट्स जो डिसीजंस है उनको कोर्ट्स जो हैं वो हैंडल करते थे. मगर 20th सेंचुरी आते आते गवर्नमेंट्स जो हैं उन्होंने इंक्रीजिंगली कॉम्प्लेक्स सेक्टर्स में जाना स्टार्ट किया, जैसे लेबर रिलेशंस में, इंडस्ट्रियल प्रोडक्शंस में, फाइनेंशियल मार्केट्स में, एनवायरनमेंट में. सो इससे हुआ ये कि ये रेगुलेटरी सिस्टम्स ने जनरेट किया बहुत ज्यादा स्पेशलाइज्ड डिस्प्यूट्स. डिस्प्यूट्स भी जब अब हो रहे हैं वो भी टेक्निकल नेचर के होने लगे, सेक्टर स्पेसिफिक होने लगे, जिसका रिजल्ट ये था कि गवर्नमेंट को क्रिएट करने पड़े स्पेशल बॉडीज अब जो एडजुडिकेट करेंगे इन डिस्प्यूट्स को, क्योंकि नॉर्मली ऑर्डिनरी कोर्ट्स के पास वो नॉलेज, वो टेक्निकल एक्सपर्टीज नहीं है. अब जिस नेचर के ये डिस्प्यूट्स आ गए, ये जो गवर्नमेंट्स ने अब इस रोज टू द ओकेजन एंड दे created these specialized adjudicating bodies within the administrative setup structure itself. Ye bodies came to be known as administrative tribunals. So they came to be known as administrative tribunals या quasi judicial authorities. Because they're not fully judicial, they're quasi judicial in that aspect. So give me a moment, let me get water. क्या हो? So another reason for the growth of administrative adjudication is the speed and efficiency that it gets into the systems. Administrative tribunals, they often provide quicker, very much quicker resolution to disputes because they don't have to go, they're very flexible in their approach. So this is particularly important in sectors such as taxation, let's say, and industrial relations. It becomes important in such sectors. Another important reason is its for its growth is the specialized expertise that it is providing. Specialized expertise. Administrative adjudication, it often possesses expertise in specialized specific regulatory fields. Let's say taxation, for example. This allows them to make informed decisions on complex technical terms. And that was another reason why we saw the growth of administrative adjudication. Now, it has its advantages and it has its disadvantages. We'll have to delve into understanding all of that. But for today's class, I think we call it a day here. We continue understanding the advantages of administrative adjudication. Then we move ahead and we talk about, we start discussing the disadvantages of administrative adjudication. Okay. But that is the subject of tomorrow's lecture. See you guys tomorrow.